Hello, everyone. I'd like to welcome you to today's presentation of the profit participation discussion. We are going to be talking about that today. I want to thank all of you for attending. I'd also like to thank the Beverly Hills Bar Association for putting this webinar together. My name is John Gaddy. I'm a partner, litigation partner with the law firm of Granatt, Phelps and Phillips in Los Angeles. I handle entertainment litigation, intellectual property, business dispute litigation. My experience has been in the area of profit participation on both sides, representing at times talent, and then also representing studios, networks, and financiers. I was counsel for and trial counsel for in the Ladd versus Warner Brothers case, which is a profit participation case. Today, I have the distinct pleasure of working with two experts in the field. First, Richard Granatt of Robinson Granatt LLP. Richard is a UK chartered accountant who has worked in the field of forensic accounting since 1987. Earlier in his career as a licensed insolvency practitioner, Richard built a reputation for unraveling financial statements and tracing monies that were due to creditors. Since 2005, Richard has successfully transferred this skill set into the domain of film and television profit participation audits, amassing an enviable track record of successful returns to his clients. Thank you, Richard, for participating today. Also with us is Philip here. I'll refer to Philip as Phil. I know that's his preference. Phil has over 30 years senior management experience handling all aspects of the media and entertainment industry. In 2002, Phil established Focus Advisory Services, providing exclusive financial and strategic consulting services to film and television production and distribution companies. His clients have included some of the largest independent film companies in Hollywood, such as Film District, Summit Entertainment, and many others. Also, prior to that, Phil was a senior vice president of business development at Sony Pictures Entertainment. His groups were responsible for all financial analysis and strategic planning for the Columbia TriStar Motion Picture Group. Prior to Sony, Phil was a vice president and CFO at 20th Century Fox International, directly managing all finance and administration functions for Fox's 30 overseas theatrical marketing and distribution offices. And I could go on with both of our panelists' experience, but I will stop there and I'll get right into it. Today, we're talking about profit participation arrangements, and we all know that they can be complex. They impact many different issues with participants and major film distributors. The program today will highlight current issues in profit participation auditing, together with strategies to maximize realizations to participants. So with that, I'd like to first go to Richard. And looking at the audits and what you're doing, what is the importance of audit rights?
Well, thanks for the introduction, John. Good afternoon, everyone. I just want to say off the bat, audit rights exist in every deal that is done. Whether it be against a major distributor or an independent, smaller distributor, there's always audit rights, and they're there for a reason. They should be exercised. They're valuable, and it's very, very. Hopefully we're going to have some time to talk about notices and tolling later. But just in case, it's so important. I want to just say that it costs nothing to put an audit notice in to a studio, and basically as a placeholder. As long as that notice is told appropriately, through the periods, then you're in good shape. If you lose the right to audit the first statement, because statements, of course, do expire, you've lost the right on a major film to audit the P&A forever. So we see that so often when clients come to us and well, did you get your notice in? No, not yet, and those rights have expired. So it is very, very important. As John said, I've been doing this work for 15 years. And, my basic takeaway is that I do believe that, when you're in settlement meetings, the studio culture very much is that, when we're talking about paying participants too much money, they feel like there's a kind of unwritten statement in the room that they feel like it's kind of their money. They have to account to stockholders. So, they do defend their positions very aggressively. And that's why, one has to audit. The other thing I just would say by way of introduction, when studios do settle audits and certain claims are, inverted commas, agreed, it doesn't necessarily mean that all participants in that project are going to get the benefit of that claim. When studios settle, there's always a global amount that's put in a settlement agreement, which is not split into different claims. And because there's NDAs that exist between ourselves and the studio, separately for every client that might be involved in an audit, you can't always share information. So, these so-called errors and mistakes can get lumped into an overall settlement. So, it's another thing one has to be very careful about.
Just briefly, just to interject, do you find that relationships between studios and participants come into play when you're dealing with these audit issues?
Yeah, I think they have to. Obviously, if one has a term deal with a big producer has a term deal with a studio or ongoing projects, they're going to be treated, to be honest, better than the one-off guy that's come in and is never going to contract with that studio again. So yeah, that does play a role for sure.
Phil, what's your perspective on the importance of audit rights and how you find that they interplay with what you do?
Well, I mean, for the purpose right now in my practice, I do settle a lot of studio audits, and you do, as Richard said, you have to be extremely careful about maintaining the rights through the tolling, because from the time you send in your notice, it's 3-4 years until your auditors actually get in there. And then it can even be years before you settle. So I'm settling audits right now that were done 4 and 5 years ago. And if you let your tolling expire, they can just walk away. So that's extremely important. But for the purposes of this presentation, I'm kind of taking the studio side on these things. So I would say the studio needs to have the tolling in place. While it seems like it's a silly game, they can't have these kinds of liabilities hanging over them for years and years and have somebody step forward 10 years later and say, you made a mistake on a statement 10 years before and you owe me $5 million. Because you can't really run a business where you have contingent liabilities that you don't know about. So that's kind of my take on that part. In terms of the studio culture, it is true, certainly, as Richard said, that the talent arrangements are extremely important. So you wouldn't see a finance executive doing something on their own that could potentially jeopardize the studio's relationship with an actor or director. they'd potentially get fired for something like that. I mean, everybody's very protective of the relationships. My point of view from having worked inside of the studios is that there's no overriding desire to shortchange participants, but that contracts are written in such a way that everybody, the lawyers, everybody in the beginning has to be extremely careful about what they're agreeing to, because generally a lot of the issues are a lack of understanding on the part of a participant that the film's profitability under general accounting practices is potentially unrelated to their defined contractual profit. So just because the film is profitable doesn't mean that they're entitled to money, because they have potentially agreed to something that's not the same as that. So that's my point of view, is that there's not really an overriding desire. There's no two sets of books or anything like that. There are definitely mistakes that are made, and there's definitely interpretations of a contract that for sure favor studio and could easily come into dispute.
So if I were to summarize that, so I guess, we've all heard people use the term Hollywood accounting. Your take on it, or your experience, has been that not so much that there's something that you would refer to as Hollywood accounting in a derogatory sense, but more that it's an interpretation of negotiated contract terms, or it's a matter of what the contract terms are that have been negotiated. Is that a fair assessment?
Correct. By sophisticated parties on both sides normally.
I'll also mention to the audience that if you do have questions, please, we'll have a Q&A session at the end that we can address those. As questions come in, I will attempt to work those in. One question we did receive is that each of you were talking about tolling agreements to work out to handle any delay with the audit process to preserve everyone's rights. Is there any language that you would recommend, or that you do see in agreements to ensure that tolling will not expire? I mean, have you seen? I know certain contracts between participants and studios or networks will have certain statute of limitations, let's say, or deadlines to bring audits. Are there any recommendations that either of you have for language that someone might look to put in a contract that would help preserve tolling agreements? Or do you think it's just something that once the audit process starts, that's something when the tolling agreement would be addressed at that point?
I think, obviously, in COVID, this has become a huge problem, where basically, obviously the studios were in lockdown, their audits queuing up. And, I think most of the studios, have been very reasonable in extending tolling because these audits have been on the books for so long. And I think they're reasonable in that regard. I think once you've put your notice in, that's the key. Get the process started, and then I think tolling, should take care of itself. But I just wanted to come back on one thing that Phil said, with these kind of, millions of dollars of contingent liabilities on a statement for a studio, which I totally understand. But, most agreements do contain a provision that basically says that statements will be issued, periodically, quarterly at the beginning, then annually, whatever it is. And then it will say that the studio has the right not to submit a statement if it does not believe that any money is owed to the participant. And that's a huge statement. That's a huge assertion. Because basically, we have clients who have come to us and said, we haven't had a statement for 20 years. And, we say, okay, let's ask for one. So we request one and we get one. And the beauty of that for us is that whole 20-year audit period is up for grabs. It's not statute barred because the expiry time runs from when the statement is issued. So, 36 months after, 24 months thereafter, whatever it is. So essentially that whole audit period for 20 years is up for grabs. And, the studio might feel that there was never a payment due to the participant, but let me give you a classic example of what we've been finding on these older statements. Say, for example, there's a provision for production costs to be recouped at the sort of midpoint of an accounting period. Well, an accounting period is normally defined in the agreement, in accordance with the statement for the 12-month period or the quarter month, whatever it is. Now, if they are issuing statements of 20 years duration and they've decided to recoup production costs by gross receipts that, on the midpoint of that statement, which is 10 years later. So you've got domestic theatrical gross receipts sitting there for 10 years that haven't yet recouped production costs. And that's kind of egregious. So, there's kind of two sides to that coin, I guess.
Before we get into the specific items, I just wanted to ask each of you, do you think there are certain things that need to exist before you actually do recommend an audit be conducted by a client? Are there certain thresholds that you think a client should look at before they actually decide, okay, yes, an audit is necessary here? Richard?
Yes, I mean, we offer assessments free of charge for all we need is an agreement, the underlying agreement and the latest statement, and we will prepare a thorough assessment as to the merits of auditing, what potential claims there may be, and we feel we can tell some, with the experience we have, obviously we can glean so much from those two documents that without even going in to do the audit, we can pretty much assess what is there and give the client a reasonable expectation of what he's going to get out of the audit, the value he's going to receive from the audit. So yeah, that very much so. And so, some assessments, many assessments we get, and we just say, it's just not worth it. It's not worth your time, and don't do it. So yeah.
I would say if the statement is in a positive, that's certainly the first step toward auditing. And I would say, but you wouldn't want to draw that line in the sand and say, because I'm not in the positive, I don't think I should audit. A smart thing to do, for example, if you were looking at a first statement or first couple of statements would be, and you got your notice in on time, would be to look at the P&A expenditure and say, well, what if that comes down by 10%, let's say, or some percentage? What would that do to my profit participation? Because if at that point you're in the positive, then you may well decide that it's worth it to audit, because depending on I've never had one where I paid money or clients paid money and we didn't get multiples of that fee out of it. The fee is usually very reasonable compared to the amount of money you're getting out of these statements. So I think it's always worth it to do. I mean, I just had a client, we're now 10 years later, I'm selling their film library, and he's like, oh, if we're unrecouped, now they get to keep the movie for another 10 years. And I was like, yeah, your movies, we can't really sell it. It's not worth anything. If you had audited, I bet we would have found enough. You're only unrecouped by this small amount. We would have easily found that on an audit. So it's not even just money coming back. It's if the agreements could be extended, let's say.
Yeah, absolutely. Yeah. I just want to say one thing. I agree. Obviously, the client's participation share is crucial. If you've got a 7.5% share, you've got to find $1 million in agreed claims to get $75,000. So, that's a huge factor, obviously.
And once a client does make the determination to conduct an audit, have you guys found that there are certain items that are most important to focus on in an audit? Or do you find that there, over and over again, there are areas that are more ripe for a better result for the client, and what you suggest a participant should focus on?
Absolutely. I mean, the program, the next part of the program talks about related party deals, purely because, if you look through all our last, 100 audit reports, the significance of these claims, certainly in value, are such a big part of the audit claims. The vast majority of deals, of course, embrace the fact that the distributor can use affiliates, obviously, in its course of business. But they're supposed to do so on monetary terms comparable to the terms upon which they enter into similar transactions with unrelated parties. This is where, the problems always come in. We're going to be talking about specific cases, in a minute. But in my experience, there's rarely a bidding process. When we've found that, a studio has sold to, its wholly owned network, for example, there's rarely a bidding process. I think it's sort of group policy that, affiliates are not audited, by the parties in the same group. This is our go-to area of, audit claims, without a question, and it can affect a lot of different areas of the audit.
I would agree with that, and then add a couple of things, which is putting overhead into distribution expenses is a very common claim. It's when you're a finance executive at a studio, it's the simplest way to lower the overhead of your group is by moving some of that onto film costs.
Right.
So it's not like a planned thing at the studio level. It's things that individual finance executives do. Having double distribution fees by the studio, and then also by their licensees, by their sub-distributors. Rebates that come in either because of media buying, the duplication of physical DVDs, things like that. Anything the studio buys in bulk, they often have rebate deals which lower their costs and are not passed on. And then the last one is a more technical one on the home video side, are costs that are really should be reductions of revenue. And so what that does is on bigger movies, it lowers the distribution fee, because instead of the revenue should be lower. So the net is the same, but by driving the revenue down, it pushes their fee down. And believe it or not, on bigger movies, you can get hundreds of thousands of dollars just on those kinds of video claims. So those are the type that I see and negotiate, and also did myself when I was at the studios.
Right. Yeah, absolutely agreed. I just wondered, on, the biggest dollar amount of those kind of, I call them the usual suspects. I think that's the way I've termed them in the program I sent out. Is really talk about these huge rebates. Obviously in the old days, theatrical prints, DVDs. The studios view those as a corporate windfall. We ask for those agreements, the duplicator agreements and the major advertising agreements, and we never get them unless we litigate, and you get them in discovery. They're just kind of they're hundreds of millions of dollars, literally, in the deals that I've seen, and the studios basically say it's a corporate windfall. It's our great negotiating skills, but that these reductions are not passed on to title. What's your view on that, Phil?
I mean, I've worked at two studios, and one passed them along and one didn't. I think they should be passed along. I think it's especially egregious when they do it on the revenue side, which I've seen a few times. So they'll get one lump sum payment from a given pay TV provider in the US or overseas and not put that through, and then take a lower amount for each movie. That's clearly not allowed in the agreements. But the studios are becoming more sophisticated now. So in the past, when they had, for example, incontestability periods, there was a sentence. Now it's like a page. And the same goes for rebates. Now they really put in there and say, you don't get the benefit of any of these rebates. And so it's worth certainly asking to get them. I've worked on some smaller movies for not huge clients, and a lot of the deal points you can just ask for and you'll get them. The
Right.
studios are, if you don't ask, you'll never get them. So
Right.
at least you can ask, I want that taken out. I want the benefit of the rebates. And see what happens. For financiers, financiers almost always get the benefit of the rebates if they're sophisticated.
I'm glad to hear, Phil, that of one studio who does pass those through. We should chat afterwards. We can give you a bit more detail on that.
They don't exist anymore, unfortunately.
Okay. Oh, that's why.
They were bought. But as a finance executive, it was a huge amount of work to, after the fact, have to put these rebates against each individual cost of every title.
Right. Yeah. But
But we did it.
Yeah. So, sorry, John. Yeah.
No, go ahead.
Yeah. No, I was just going to, we're talking about related parties, just maybe mention a few, a couple of high-profile cases. Some of our attendees can get, who don't know, can get an understanding of the sorts of things we're talking about. I mean, the Bones case, with the Fox case with Bones, there were 4 areas where the judge highlighted, instances of, related parties which, shortchanged the participant because they were dealing with affiliates who weren't paying and didn't have the incentive to pay an arm's length price in the same group of companies. Like, why would they? So it wasn't just the Fox Studio selling to the Fox network. It was also in international television in England, where the Rupert Murdoch British Sky Broadcasting was the licensee. Affiliates in France and Spain, where Fox-owned licensees were used, and of course, when Fox had a share of Hulu. There as well. So, it's nice to know that when the judge made his judgment in that case, he referred to, like, for example, he evaluated the damages in each constituent of those transactions by reference to, so for example, on the network deal, he used House, a universal arm's length license to value roughly what Bones should have been. And it was obviously a hell of a lot more than what the participant enjoyed through the affiliated license. The Who Wants to Be a Millionaire case was really, I'd say, an even more egregious case of self-dealing. Basically, the UK show was, the format rights of the UK show were licensed to ABC. And they designated a little-known production company to produce the show, and it was just arranged that the ABC would pay just that license, just the production company's cost. So, by definition, there could be no profit flowing through to Celador, and ABC obviously got huge billions of dollars in advertising on that show, which isn't due to network, advertising on a network is never due to a participant. So, they were the huge winner, and the Celador were the huge loser, and they got awarded over $300 million on that case. So, it's just a flavor of how big these cases can get in these areas.
With the, obviously a lot of merger and or acquisition activity in the entertainment industry that we've seen over the years, 20th Century Fox being acquired by Disney being an example.
Yeah.
These related party deals that you see, do you anticipate them to become more significant as we see more consolidation or anticipate more consolidation in the entertainment industry?
I guess it's like, the big accounting firms. It used to be the big 10 and the big 8 and the big 6 and the big 4. I don't know. But, it's this thing I said at the beginning. Basically, when the interests of for example, a showrunner and the production company are not aligned, then it's never going to be fair. If you basically have a situation where, the studio is basically selling to an arm's length party, then the interests of the production company wants to make as much money as it can, and so does the showrunner. So, it's an arm's length proper process. So I do feel that it's becoming more and more of a problem. I mean, I think, Disney acquired Fox really to control Hulu. And, we're seeing that.
The other issue that I know you guys have talked about is imputed network license fees. First off, I'm sure most people in the audience have experience with it, but just briefly, what do you mean when we're referring to imputed network license fees? And then I'd also ask, what are the issues that each of you run into in deals involving imputed network license fees? Are there the more significant issues that you actually see when you do deal with imputed license fees?
Phil, do you want to start with that?
Sure. I mean, my point of view is that it's kind of something similar to issues that you'd also see in allocations of TV package deals. There's always a circumstance within the studio where some assumptions have to be made as to what a price is for a particular program. And there's no objective value for a show necessarily, so there's a lot of leeway within that. So I think having a contract that's very specifically talks about things like that would be extremely helpful once it comes down to it, because as we were discussing before, we noted that the current Walking Dead contract seems to allow AMC, at least according to one judge, to a lot of leeway, way more than one might expect, to say what the payment was from themselves for their own show to exploit in the US.
Right.
So that's what, so imputed license fees are all good and well, but it's the same as giving someone who doesn't have the same alignment of interests as you the power to determine your profits, and that's never going to work out well. And so I've seen a lot of deals where people went in and really thought about certain clauses in a new way. So rather than necessarily just take what the studio gives them, come up with your own solutions beforehand and see how far you can push those, because otherwise you're going to potentially end up in a situation where it's not necessarily fair and there's nothing you can do about it because you signed a contract that says they can do that. They can be unfair.
Right. I mean, that's right. I mean, in the Walking Dead case, that the way they set up the imputed license fee in the deal was, on that phrase that I used before, on monetary terms comparable to the terms on which AMC Network would enter into similar transactions with unrelated third parties for comparable programs. Now, this purports to establish a principle of fairness, but there's no mechanism to put that into effect. I mean, what is the fair value? There is no, you can't just leave it like that. And I think that's what happened in that case. And, there's so much confusion seems to be, between both parties as to, when they got the definition. I think the plaintiff was saying, well, yeah, we're great. We got this definition after after season one, when we knew the show was going to be a great hit. So obviously specific things relating to this case. But as a general principle, it's all very well putting an imputed license fee language like that into a deal, but without a mechanism to set that license fee, basically, customarily you're supposed to get episodic fee increases after a certain season. Deficits aren't being recouped. There's all these things that are kind of left to be negotiated, and sometimes they're not negotiated very well.
When each of you as professionals, and when you're looking at it from an audit perspective, come across deals that have an imputed license fee. Looking in hindsight, I guess, what would you like to see, Richard? I guess you touched on a little bit, but what would you like to see if you're going to, if someone is to utilize a imputed license fee? How does one best protect themselves if that's the type of arrangement you're going into?
Well, they have to be better negotiated, I guess. I mean, without those parameters of, if you're going to have flat episodic licenses, for example, that's just not in accordance with how those kind of network deals would normally work, right? Some cast members are getting increases, but, the participant is not, and that kind of thing. It just doesn't sit fairly at all with, the way the deals are supposed to work. And, giving a percentage, covering a percentage of production cost, it's all, kind of arbitrary. And obviously, if you're not going to increase episodic fees, then you're going to have huge deficits. So it's just something that I think one has to give more thought to the way it's going to work before, before the ink is dry on the paper kind of thing.
Phil, do you have any parting thoughts on imputed license fees and how you look at those?
I mean, I would say for this and, several other type issues, the more concrete you could potentially make by having real world examples. And so by using potentially parameters like production cost, using parameters like advertising income, looking at maybe what other shows that particular network and or financier had that you could refer to. So all of these kinds of things, most favored nation clauses.
Right.
So these are the types of things you could put into a deal to try to make it better.
When you're Phil, when you're looking at something in an audit process after the fact, are there particular procedures that you follow to try to test whether an imputed license fee is fair or has been done in a way that is I'd say fair or fair to both parties?
I mean, I'd have to, because I work on deals across film and television, I look at information that I have from other transactions and try to see to the extent that I can whether something looks like a fair arrangement. And same thing in allocations of prices for TV contracts to find out what they did and see if that seems reasonable. When I was at Sony, my groups did the allocation of TV contracts, and we came up with a methodology that we thought was reasonable. And there's not one that one could say, every television show should be worth this, every movie should be worth what its box office was, let's say, because that's not the case. Could be very R-rated or some other reason why it's not as valuable for TV. So I look at everything individually, but I try to push back. And I think the best way when you're negotiating with the studio is to generally not take what they say as face value. As they're not lying, but they say things which don't necessarily make sense and you can go do your own analysis. Don't just take what they say, oh, this is the way we do things, and then say, oh, okay. Because a lot of times the person telling you that doesn't really actually even know the way the studio does things in that division.
Yeah, I mean,
I was just going to ask you, Richard. Yeah, I didn't mean to interrupt you, but when you're in the audit process, do you see that the studios or networks are willing to negotiate on the language of the imputed license fee, or do you find that is a difficult item to address in an audit, and then it eventually leads to litigation if that's the final answer.
Yeah, absolutely. Yeah, the monies are too big to negotiate. I guess it's just there's too much at stake, and yeah, it's. But just picking up on what you're saying about allocations. When you sell a group of films, to a TV station, then of course it's up to the studio to allocate that contract sum amongst the titles in the package. These are situations we've been finding for many years. Age and success are the two real parameters that we use to try and establish whether or not the picture being audited has got a fair slice of the total. I mean, John, you know as well as anyone with the Ladd case, I think that was a straight lining thing, right? Yeah, where the police academy film, basically every film in the package got exactly the same. So, films like Police Academy, which did really well, got the same as films no one's ever heard of. And the reason being that there's probably no participants on those unknown films, and there's no equity leaving, the studio's organization, which is what I said at the beginning. It's outflow of, every time you're paying a participant, it's an outflow of equity. And they want to avoid that, come hell or high water. So, yeah.
Well, it'll be interesting how the Walking Dead and other matters that actually do play out. Learn more as we hear those decisions coming out.
Yeah.
The other area I wanted to turn to is the digital platforms owned and operated by studios. Obviously, we see a lot of movement toward the digital platforms. And I wanted to hear from each of you how you are dealing with the new streaming income in audits and how that's impacting what you do.
Right. Well, yeah, I mean, obviously in the last few years, there's many examples of studios creating their fully owned, SVOD platforms to compete with Netflix, to compete with Amazon. And again, it's the same kind of thing. It's an intra-group transaction. And we're not finding that the license fees passed over are sufficient. And of course, it's a double whammy because you're getting a lower license fee, we believe, within that kind of intra-group transaction, and you're missing out. If you're showing it on the studio's new wholly owned and operated platform, then you're not showing it on Netflix. You're not showing it on these other independent providers who'd be paying you a lot more money. So you're kind of losing twice. I mean, I think there was some research done that basically said that in its infancy, Netflix was paying around 175% of its subscription revenue, through to licensors. Obviously, i.e. running at a loss when it first launched. No one cut them a break when they first launched. But if you look at the amount coming in from, an affiliated platform to, every studio now has its own or is getting its own, it's a fraction of the subscription revenue. So, it's just another way. And again, it all ties into this related party situation where one pocket is paying another pocket and, there's no incentive to pay the full price.
Phil, what's your take on the digital streaming platforms and the revenue and how that is impacting audits?
Well, I'll take the studio position on this and say, throw out a couple of points that if the studio, if the studio, let's say, has purchased the show for their network, for one of their networks, and then also shows it on another platform, they would take the position that they don't have to pay twice, which I kind of, as the studio position, agree with. That in the past, if there was no limitation on the number of runs on a particular network, what's the difference really to a participant? If the studio owns it during that certain number of year term, what's the difference if they show it on a wide variety of platforms or just show it on one TV channel? And that's common even in third-party deals overseas. You see very large conglomerates in France and Germany buy TV rights and show it across a wide spectrum of channels. So that's one thing. And the other thing I would point out is that things are not always that friendly between studio affiliates. And so you have executives whose bonuses depend upon, on the one hand, getting high license fees for their product. And then you have another executive who's running a platform who says, I don't want to pay high license fees because now I'm going to get a lower bonus. So I think that in a lot of cases, there is a similar level of competition within these large corporations as there is outside in just going to third parties, because of the incentives of executives to drive the profit, their particular profit center higher.
That's kind of interesting because we finished an audit of a major TV series a year or two ago, and we had these arguments. They were putting lots of repeats on their wholly owned SVOD platform, and they basically said they made the point that this is part of our network window, so we're allowed to do that. And then, of course, we countered with, if they're repeats, we should be getting repeat fees, contractual repeat fees for these runnings, for these airings. So you can't have it both ways, kind of thing. So it's kind of interesting, the back and forth on that. But yeah.
In the past, we're all familiar with home video, home entertainment. There's with DVDs and whatnot. There were usually working off of a 20% royalty rate, usually. How do these issues with the digital platforms, do you see that being applied also to the digital platforms, this 20% royalty, or do you see it, how do you see it playing out?
Well, that's another, I think an egregious position that studios can take, unless it's contractually provided that, for example, electronic sell-through is reported a 20% royalty. There's no justification for the studio to retain 80% of gross revenue when there are really no costs of, very few costs, let's say, of getting that out to market. It's not like a DVD, which you've got to, manufacture and ship. And that's really why the 20% royalty came into being so many years ago. You can't apply that to new media, digital revenue. I think that's an egregious position. The other point there is that some agreements do have, provisions that say, have a distribution fee of 15%, but, the distribution fee will only be 50% of that amount, say, if third-party licensees are distributing. So, for example, we see this with things like iTunes in the old days. iTunes are effectively a sub-distributor. I mean, there's no minimum guarantee, there's no license fee. They just retain 30% of the revenue that's earned from their distribution. So how can you charge a full distribution fee when they've taken their 30% distribution fee, as Phil referred to earlier, like the double dipping of fees? That's another thing to look out for, I guess, on that side of life.
Well, I guess from the studio perspective on the video side, I would say it's no different than having a retail price that Walmart sells at retail and the studios get a wholesale price. So there's always been a discrepancy as to what the consumer pays and what the studio gets. But my perspective on the, usually VOD is at a 20% royalty. And the reason that is because it says it in the contract. And so if you don't want it to be that way, then you have to change the language of the contract. I mean, there are some older contracts but that have to be pretty old, that don't anticipate it.
Right.
But this concept has been around for a while. So, but that's, at least what I see, is that normally the contract specifically allows the studio to charge the 20%. And if you, again, don't want it to happen, then you have to not have it be in the agreement. And a lot of times, things that people don't realize is that they'll sign an agreement that might be silent on something, and they don't have the standard terms, which are like 20, 30, 40 pages, you have to have the standard terms. The standard terms is where all of these things are defined. So I've gone into deals where I'm negotiating a deal with a client and they're so happy. Oh, we got everything. This is great. And I'd say, we're not even close. We haven't gotten the standard terms. And I'm asking for them constantly because the studio doesn't really want to give you them. And then you get it, and the standard terms completely eviscerates everything you've already agreed to in the other agreement. So, I would go back to the studio and say, look, we know each other. Come on. What's the point of my client hiring me to do something if I get them a horrible deal that they could get themselves?
Right. But isn't there normally a provision that, the agreement, the terms, if there's the agreement, agreement terms override the standard terms, but... Yeah,
but they'll be silent. What they usually do is they're just silent on it.
Right. Yeah. I mean, of course, we can only audit an agreement that's in front of us. We come in much later in the game. We don't get involved. We do sometimes get asked to get involved in assisting with contract negotiation, but it's not usual.
So the moral of that story is, from the auditor's perspective, is attorneys do your job. Right?
Absolutely, yeah. Absolutely right.
One good thing though is that since kind of the economic crash, 10, 11 years ago, the studios have moved away from first dollar gross, which was always at a 20% royalty. Bigger players might be got 25% or more. And they've moved toward now true break even. So they're not paying on first dollar anymore. Right. A percentage of the revenue. Now the movie has to make money from the studio perspective. And in those deals, now they're giving out video at 100%. Less costs, less a distribution fee, but it's still way better than 20%. So at least all the big players who are my clients have all been moved over to 100% deals, but they're much closer to reality.
Right.
I wanted to move on to merchandising and brand association. We've all seen that film and television based on animation, comic books, other brands has become a bigger player as part of the content increase. And I wanted to see from your perspectives how that merchandising and brand association is coming into play in audits and impacting audits, and what you guys are seeing.
Right. Well, I mean, you're right. Some of these animated films and, multi-title franchises, which is obviously more, de rigueur these days over the last 20 years, to have these huge franchises, that they attract tons and tons of merchandising. I mean, hundreds of millions of merchandising on things like Dora the Explorer and SpongeBob. It's just astronomical. And, catching all that revenue, making sure everything's reported is a big part. It's become an increasingly big part of our work. I mean, we use research now as a big tool in our audits to just try and gather all these different revenue streams. I mean, we just finished auditing a very successful cable TV show, and we pointed out to the studio, that we found so many, and all you got to do is go online and search these things, cruises and food preparation stuff that was associated with our brand that we're just not getting any credit for on the statement at all, zero. And we literally found about 5 different sources of revenue out there. And, the studio did actually correct some. And, did say that one was an error. They just forgot to report it. And, so you really have to be active in researching these things. And, the other thing is how's this revenue allocated between, different titles? I mean, your client might just have a share in 1 or 2 of the titles, and you might find that all the merchandising was allocated and reported on a different one in the franchise. So, the studios do say they have a way of making those allocations, but, we asked for these style guides, apparently, which is one of the things they use. But I'm not really sure how the studios really do that stuff. I'm not sure if Phil can throw a bit more light on that.
One way to do it is, for example, so when I was at Fox and we had the X-Men, the first movie, it was
Right.
Marvel was still just a standalone company,
Right.
much smaller than it is now. Hadn't yet had any big successes, and the way we had to make something that was, based on the movie, the toys would say based on the film, The X-Files, and they'd have to look a little different, X-Men, they'd have to look a little different than the existing toys. Terminator, every Terminator movie has been made by a different financier and a different owner. So everyone, and there's Terminator pinball machines, Terminator slot machines, and everyone, it's the same sort of thing. As you were saying with the style guide, everyone is slightly different look.
Right.
But so much of it depends on, like you were saying, doing research and pressing your case.
Absolutely.
I did a hugely successful animated TV show, and the movie did pretty well. There, as you were saying, not one penny of merchandising in there, and said, "Oh well, it's all the TV show."
Yeah,
And
exactly.
we were like, "Wait, what? The movie? We bore the cost. We bore $100 million of P&A revenue that advertised this across the world."
Right. Absolutely.
That came out of our share because we were financiers in that case.
Yeah.
I said, "That's not reasonable. You have to give us." And they tried everything. Oh, our affiliated TV channel won't give us the information. And I said, "That's preposterous. Come on."
Right.
If we sue you, we'll get it. So,
Exactly.
At some point you cooperate a little on these negotiations, but it always comes down to, if we sue you, will we get it? And do you want us to just sue you?
Yeah, absolutely. I mean, it's interesting. So I had exactly the same, I've just been reminded by you, I had exactly the same response about, no, it was all on the TV show. We were watching the movie. No, the TV show got 100% of the merch, everything. And I had exactly the same response. And you're right. Ultimately, we do have the power to take this further, to litigate, or at least posture litigation. And, settlements of these audits are really the most important part of the audits. It's all very well doing a great audit report, but then you've got to go and get value for your audit claims. And, we feel we're very strong in that area as a firm. And, we have certain strategies that we like to use in different cases. Can't leave it at that right now, but it's very important. Obviously, it's the most important part of what we do.
This discussion is great. In the last, I know we have a few minutes left, and I wanted to just see if there are. You guys have done a fantastic job of walking us through some of the things that are happening in the developing in audits now based on new activity, whether it's digital platforms, merchandising, imputed license fees that have come up, related parties. What are some of the usual suspects, kind of the true and tried issues that you still see coming up in audits, and we can kind of conclude on these points?
Yeah, the usual suspects. I think we've covered, just looking at my list, I think we've covered a lot of them, to be honest, but miscalculated interest charge on production costs. I say it because it's such a huge impact. It's such a big dollar amount normally that, if you tinker with the principle of calculating interest, it can really affect the participant's statement. Making sure that if there's any tax credits due for filming in certain locations, that they're credited against production cost. Phil mentioned earlier, that this ongoing argument between auditors and studios about, is it an overhead or not? I mean, a distribution fee has never been defined, to my knowledge, in any deal. It just says X%. It doesn't say what it covers. So, every time overheads come up, well, is it covered by the fee? We think so, and they think, no, it isn't. These arguments just, rally on for long periods of time. They always have. And, allocating monies, amongst films in TV sales is a constant recurring issue that I guess they're the kind of the major usual suspects, I guess.
Phil, anything else you wanted to add to what you think are some of the things that people should in audits focus on and have been, other than what we've talked about. Anything you add to that list?
No, I think we've covered, most of the big ticket items that I've come across.
Well, I think we are at the end of our 1 hour time period. I want to thank Richard and Phil for a very insightful and informative discussion. I have worked into our discussion some of the questions that were coming into us from the attendees. So I think I have gotten to the questions. If anyone else attending has any questions that you'd like to present to the panelists, you can go ahead and type those in now. We have a few minutes where we can address your specific questions, hopefully. So I'll just see if anything else comes in. But if not, again, I want to thank Richard Granatt and Phil Fear for your participation today. It was greatly appreciated. I think very insightful. I learned a few things. I hope attendees learned a few things today. So that's well appreciated. I thank you guys for taking the time.
Great, thank you very much, both of you. Yeah, very enjoyable.
Thank you for the invite.
Just a couple of questions that have come in. One question is the question I think is a good one. It says, what do you think about box office bonuses instead of profit participations? And I think I might just even add to that, what do you think about getting away from profit participation or net income or net profit or adjusted gross receipts, profits, and going to more of a benchmark? Maybe it's, if you're talking about streaming, hitting certain streaming numbers or downloads, whatever it may be. What do you guys think of that? And the question was specifically to box office bonuses too. I think, do you think there's a benefit, or do you see it going toward a more specific, benchmark for a payout to a participant? Phil, what do you think?
I'm totally biased.
I don't
want to see any changes, or it won't be very good for our practice.
I think it's a good idea. So for smaller participants, it's a very good idea. You don't have to. You're going to end up with words on a page that don't mean anything. So at least get something out of it. Of course, if the movie turns out and it gets sold to a streamer for double the production cost, you get nothing. So that's potentially the risk, that the movie made a lot of money and you get nothing. But generally, I think box office bonuses are very good for smaller participants. And then for bigger participants, they're also good because you'll get box office bonuses against your normal back end. So they're basically just advances on your back end, and then you don't have to worry about as much about issues coming up because you're going to get some money up front. And then if the movie is extremely successful, you'll still get your percentage share less what you already paid as a box office bonus. So I think it's very good, although you have to be extremely careful in today's day and age where a lot of movies are bought by streamers.
Anything to add, Richard?
I'd just say advances against participation are better than no participation at all from my viewpoint. But having said, we are, obviously we don't get to audit a project until it's, been out there being distributed for, a few years, because obviously wouldn't be much to audit. So we're always a few years behind the game. So we'll just order whatever's thrown at us, basically.
The last question I'll throw out to you, which I'll admit at the beginning of asking it may not be fair to you guys, because it is more of a attorney question, but I'll ask it this way. Based on what you see in audits, Richard and Phil, would you, after the fact, suggest to attorneys any specific items that should be added into profit participation language that would make your life easier as an auditor, let's say?
I mean, I just saw one recently which, you know, got us an immediate settlement. So instead of fighting over what's overhead and what's not overhead, the agreement simply said the overhead can't be more than X. So we got an immediate settlement on the amount over that amount. So it was because normally they would say, this is overhead, we don't deny that, but for these reasons, this is why this overhead should be allowed to be a distribution expense, and we always include it as a distribution expense. So to get around that, you simply just say, the overhead on this movie can't be more than X. And that was it. Boom, and we got an immediate settlement.
Yeah, I think on smaller movies, you know, it's more commonplace to, you know, just see distribution expenses caps are this, and, you know, home video in the old days, you know, the manufacturing cost per unit is, you know, $2.80. That's it. And if you're $2.80, and if you're over that, then, and it's amazing still how many times the studios go over the cap. From my experience, where, you know, it's just, I think a lot of these things are just forgotten about, and, you know, when the statements are prepared, they just, you know, these things aren't really looked at again, to be honest. But
great. Well, again, Richard Granatt of Robinson Granatt LLP, thank you very much. And Phil Fear of Focus Advisory Services. Phil, thank you very much. At that point, I will end the program and let everyone know that Beverly Hills Bar Association will be sending out whatever MCLE paperwork to you. So you'll get credit for attending today's session. And again, gentlemen, thank you. And attendees, thank you for your attendance.
thank you, John.
Thank you. Thanks, John. Great job.
Thank you.